Hi everyone, my name's Maeve Delargy and I am a member of the Outlaw Committee and also on the legal team for Equality for Children. So I'm delighted to welcome you to this event today, the joint event between both of those groups. And we're very lucky to be joined by Lydia Bracken and also Jenny and Elaine to share their personal story. I will, thanks guys, yeah, we're here. I will first of all pass you over to Ranae von Meding, who is the CEO of Equality for Children, to tell you more about that campaign, and then we will move on to the legal part. So Ranae.
Thank you, Maeve, and thank you to everyone joining us today. I'm sure some of you have been at our other two sessions that we've had this month, but for those of you who are joining us for the first time today, as Maeve said, my name is Ranae. I am the CEO of Equality for Children. I'm also a same-sex parent to two children with my wife, Audrey. A bit about Equality for Children. We are a not-for-profit organization which was founded in 2019, mainly by a group of LGBTQ+ parents and some allies. And we came together with the sole mission to fight for equality for all children of rainbow families in Ireland. There are a couple of key areas of work we do, and these are really to raise awareness, educate our community and the public, and to progress the legislation that we need for our families through political engagement and in working with other organizations. And we are a fully volunteer-led campaign. And if anyone on this call would like to find out more information about the work we do or ways that you might be able to support us, please do get in touch with us either through the website or any of our social channels. And again, thank you so much to the Outlaw Network and to Maeve and your colleagues for co-hosting these events with us. And thank you so much to Lydia and Jenny and Elaine for joining us today. I'm going to hand you back over now to Maeve.
Yeah, just to properly introduce Dr. Lydia Bracken, who is Assistant Dean of Equality, Diversity and Inclusion in the Faculty of Arts and Humanities and Social Sciences and a lecturer at the School of Law at the University of Limerick. If you know anything about this area, you'll have heard the phrase pathways to parenthood a lot. And that comes from a briefing document written by Lydia on behalf of LGBT Ireland. So she's really been involved in this area from a very, very early stage. I believe she was with LGBT Ireland making a submission to the joint Oireachtas Health Committee on this. So, you know, a real expert. We're very lucky to be that she's giving her time today. And we, you know, as everyone knows, this is a series. So we've already discussed couples who are automatically entitled to a birth certificate with both of their names on it on the birth of their child. Last week we covered couples who are able to apply for re-registration to get a birth certificate, amended, I suppose, a new birth certificate that has both of their names on it. And this week what we're covering are all of those people who are unable to, they're not covered under the legislation, and so they're unable to get a birth certificate and all that means. So I will hand it over now to Lydia to explain a bit more. Thanks.
Okay, well, thank you very much, Maeve, for that lovely introduction, and thanks very much for the invitation to speak today. If you just bear with me one moment, I'm going to share some slides, and please just shout at me if they're not visible or if my connection is very bad, because unfortunately it is a little bit weak today, but we'll press on. Okay, so hopefully you can see some slides. And as I said, just stop me if they are not visible at any stage. So I've been asked to talk about families who are not covered by the Children and Family Relationships Act 2015, and I'll refer to that as the CFRA. Just to say a little bit more about myself, even though Maeve gave me a lovely introduction just a moment ago, I suppose my research focuses on non-traditional families and new family formations. And I always have to promote my books. So my most recent book is Same-Sex Parenting and the Best Interest Principle. And that was published last year with Cambridge University Press. So this book presents arguments in favor of the legal recognition of same-sex headed families that are based on consideration of the best interests of the child. So it essentially uses a children's rights perspective to advance the arguments. And that's the perspective that will inform, I suppose, the content of what I'm going to be talking about today. So before I talk about who is not covered by the CF4A, I'll very briefly mention who is covered, just to give some context to what I'm talking about. But of course, these aspects were covered in the series over the past 2 weeks. So firstly, donor-assisted human reproduction, or DAHR, for the purpose of the legislation, is defined as any procedure performed in the state with the objective of it resulting in the implantation of an embryo in the womb of the woman on whose request the procedure is performed, and one or both of either the gametes or the embryo is provided by a donor. So as a starting point, if your procedure doesn't fall into this definition, it's most likely excluded from the CF4A. So for example, surrogacy would not be included in that definition, so we know that surrogacy is excluded from the legislation. Parts 2 and 3 regulate donor-assisted human reproduction, or DAHR. And as I'm sure everyone on the call is familiar with, or is aware of, the fact that this legislation was signed into law in April 2015, but it was only commenced in May, or parts 2 and 3 were only commenced in May 2020. So there was a 5-year delay in terms of commencement. In terms of who's covered by the CF4A, again, as you've been hearing over the past 2 weeks, broadly speaking, there are kind of 2 categories of DAHR that will be covered. So firstly, you have children conceived after the commencement, after the 4th of May 2020, and you have children conceived prior to commencement. So if you engage in a DAHR procedure that meets all of the requirements of the CF4A, and that takes place after the 4th of May 2020, there will be automatic legal parentage for the woman who gives birth, who's regarded as the legal mother, and then the spouse, civil partner, or cohabitant, as the case may be, of the mother. So the gamete donor, that is your sperm donor or your egg donor, is not regarded as a legal parent, but that's only where specific conditions are met. So your procedure firstly has to be conducted in Ireland. You must use an identifiable donor, so anonymous donated gametes are not allowed to be used. Various consents have to be given, and so on. So there's a number of conditions that would have to be met. It's also possible for a retrospective declaration of parentage to be made. So that would be where the child was conceived prior to the 4th of May 2020. And one of the parents is not currently recognized as a legal parent. So in that situation, it is possible to make an application to court to retrospectively be recognized as a parent. Again, however, there are a number of conditions. So firstly, you can only apply for the retrospective declaration of parentage where an unknown donor was used. So if you've used a known donor, you can't make that application for the retrospective declaration. Also, the legislation specifies that the child must be born in Ireland in order for that declaration to be made. So by looking at who is included, we can see at least some of the people who are not included in the CF4A. So as I mentioned, in relation to the retrospective declaration of parentage, that will not be possible if the child has been born using a known donor. For children conceived after commencement, the DAHR procedure must be performed in the state. So if you travel abroad for your DAHR treatment, you will not be entitled to automatic parentage for the purposes of the CF4A. Non-clinical DAHR is also excluded from the CF4A. So if you engage in your DAHR procedure at home, or essentially in any setting that is not a fertility clinic or a hospital, you will not be entitled to the parentage provisions that are set out in the CF4A. And then, as you mentioned, surrogacy is not regulated either. So the absence of specific provisions to address the categories that I've just mentioned obviously creates a number of difficulties for the families who are involved. And in fact, female couples are probably at more of a disadvantage than opposite sex couples, where they fall outside of the ambit of the 2015 Act due to the operation of our existing laws. So where a family falls outside of the CF4A in the ways that we've just mentioned, legal parentage will be allocated in the same way as any other conception. So the legal mother is always the woman who gives birth to the child. If the legal mother is married to a man, he is presumed to be the legal father. However, if she's married to a woman, there is no presumption in favor of her spouse. If she is unmarried, or i.e. unmarried to a man, then the man listed on the birth certificate will be presumed to be the legal father, but both presumptions in favor of the men can be rebutted by DNA evidence. So ultimately, the genetic father can be recognized as the legal father. But from this, we can see that while opposite sex couples to a certain extent kind of can work around the fact that they might not be covered by the CFRA, female couples don't have that same opportunity, so they are particularly affected by the absence of specific provisions. In my view, the law's failure to embrace all of the DAHR families that we mentioned is a children's rights issue. So children will be most affected by the law's failure to recognise their families. In families that fall outside of the 2015 Act, the child will usually only have a legal relationship with one of their parents, at least in the case of a female couple. So this is despite the fact that both of the parents will be caring for them on a day-to-day basis, but the non-legal parent might lack legal tools needed to actually undertake that caring role. Guardianship is a possibility, and I'll talk about that in just a moment, but even if the non-legal parent is awarded guardianship, the child will still be disadvantaged in terms of automatic inheritance rights in respect of that non-legal parent, citizenship rights, kinship relations with the wider family, and so on. So there's a number of negative consequences as a result of the failure to legislate in these areas. So it is possible for the second or the non-legal parent to apply for guardianship under the CFRA where certain conditions are met. And this includes where that person is married to or in a civil partnership with, or has been for over 3 years, a cohabitant of a parent of the child and has shared with that parent responsibility for the child's day-to-day care for a period of more than 2 years. So you can apply for guardianship, but there's a 2-year waiting period. Guardianship essentially gives the person certain decision-making powers in respect of the child. So for example, you can consent to medical treatment on behalf of your child, but it's not equivalent to legal parentage. So I suppose in particular, it should be noted that it effectively expires when the child turns 18. So it does not create a lifelong relationship between parent and child. And also it doesn't affect things like inheritance, citizenship, and so on that we just mentioned. So a number of recommendations for reform have been put forward. As Maeve mentioned, back in 2018, I was involved in drawing up a document for LGBT Ireland, which is the Pathways to Parenting document. And that puts forward specific suggestions for legal reform in the 4 areas that I mentioned earlier. Many of the suggested reforms from that document are now supported in a new document that was issued by Professor Conor O'Mahony, who is the Special Rapporteur on Child Protection. And his recent report is a review of children's rights and best interests in the context of donor-assisted human reproduction and surrogacy in Irish law. So among other things, Professor O'Mahony recommends that a mechanism should be put in place to allow for the recognition of non-clinical procedures where certain safeguards are met. So for example, he suggests that the couple would still need to give information to the National Donor Conceived Person Register, as would be the case if a clinical procedure was used. And also, Professor O'Mahony puts forward recommendations for the use of retrospective declarations of parentage in cases where a known donor was used. But again, subject to certain safeguards to, I suppose in that case, ensure that the donor's rights are balanced in terms of the proposal. So Professor O'Mahony's endorsement of reform in this area is obviously very difficult to ignore, given that he is the Special Rapporteur on Child Protection. But it is now up to the Oireachtas to legislate on these matters. However, I think it's not all doom and gloom, and I can end my portion of the presentation, at least on a somewhat hopeful note, that we will see reform in this area shortly that is reflective of the best interests of children. So I'll leave my part of the presentation there, and I'm happy to answer any questions that might arise later on.
Thank you so much for that, Lydia. I am now going to ask Jenny and Elaine to unmute themselves. Hello.
Yep. Hi. Hi.
There we go. Okay. Thank you so much for joining us. It feels funny to be interviewing my friends, but I'm delighted that you're here today, and that we can have a chat about how what we've talked about impacts on your family in a very personal way. So I think you have some photos you're going to share with us.
Yeah. Yes, we'll do that now.
Fabulous. There she is. We can
There
see
she
her.
is, the boss of the house.
Beautiful. So yeah, I mean, if you want to share your photos, and kind of maybe one of you can take the first question, and that is, when and how did you decide that you wanted to become parents?
You go.
You go. I was never going to be a parent, so so that's a good one to start with. No, I suppose when I met Elaine and knew that she wanted a big family, it was the first time I ever considered wanting kids. And I wasn't going to lose out on a life with Elaine because I wasn't willing to reconsider my stance on having kids. And once we started talking about it, it was kind of inevitable from the beginning of our relationship that that's where we were going, and that we were going to build a family together. So yeah, that's when I met this one.
Yeah, I grew up in a big family, so I've always had kids around and enjoyed being around children, and so it never even crossed my mind not to have children, even though it's a little bit more complex in our situation. And Jenny's arm wasn't too hard to twist, in fairness. So yeah, that's how we decided.
That's funny. I never would have known that, Jenny, that you didn't want to have kids, because anyone talking to you now, like you're all about the kids now. So that's funny that that you didn't initially want to have them. So then when you decided that you were going to have kids, how did you kind of start, researching that? What steps did you take to kind of make that happen? What route did you go down first?
Well, we started, probably 7 or 8 years ago.
At least, yeah.
So we started the process. Jenny was approaching her late 30s, shall we say. And, we thought, well, if we want to do this, we kind of have to act fast. And once we decided we wanted children, Jenny was more keen to carry a child. That was the only part of having children that I wasn't keen on, was actually carrying the child and giving birth. And that was the only part that Jenny was fully on board for. So we started investigating those opportunities. We engaged with a clinic in Dublin, went through, initial consultation. They talked about the odds and, the process, and we thought we would beat all of the odds, of course, and have our child first time round. So we went for, over the course of about 1.5 years, I think it was 4 rounds of IUI with Jenny that sadly weren't successful. And at that point, we were, getting pretty broke, but also pretty exhausted and worn out from the process, and found it very difficult and challenging, I suppose, emotionally. So we decided to take a break. So we did that, I think, around 2015. We decided late 2014, early 2015, let's just take a break from it and come back to it when we're in a kind of emotional state to do that. And then marriage equality came along, and we thought, well, let's just get married first, and then we'll talk about it after that. So I suppose those 4 rounds were very difficult for both of us, especially Jenny, physically. Being on the drugs involved, and we had quite an emotional response to having to have a donor in our lives as well, and what that meant, what that would mean for our family, for our child, how we would navigate that kind of into the future. and, you know, went back and forth. At the time, clinics were offering both anonymous and non-anonymous donors, and we went back and forth quite a lot around which was more appropriate for us, for kind of our family planning, but also for our subsequent child or children, and how that, you know, the impact of that would be on their lives, and how we would manage all of that. So there was, I suppose it was an intense time for us. And
so then,
yeah.
Sorry. No, I was just going to say, so how did you move on from that? Like, you know.
So during our break, we got married, we set up business, we did loads of things, and we continued the discussion. And, you know, very early on in the process, before we ever started with Jenny, she said, you know, if we ever wanted to consider a donor, a known donor in my family, I would love to ask my brother. And I said, no way, that's a terrible idea. That would be too icky and weird. We're never doing that. But we started talking about that again, kind of post-marriage, and, you know, how that for us would kind of resolve some of the concerns we had around, you know, knowing who our child, knowing who their kind of genetic father was or whatever donor was, having a link with both of our families, and the potential interruption of a donor someday coming into our lives or our child's life. So it ticked a lot of those boxes for us. So we decided that, you know, that was the right decision for our family, and started pursuing that.
Elaine was carrying at this point.
I was carrying at this
Obviously.
point, to clarify. Sorry, yes.
You would think that would be obvious, but yes,
No,
it's good to
important to
clarify.
say. Yeah.
Yes. And so then, did you approach clinics, you know, asking for them to assist you?
We did a number of clinics, and they, you know, the CFRA still hadn't commenced, so there was still a lack of clarity around known donors and the CFRA, and so the clinics obviously were offering partner donor procedures through IUI and IVF through heterosexual couples. So it wasn't that they couldn't offer us that same service, but they had, I suppose, a lack of clarity around the legalities in terms of non-partner known donors. So we went around the houses with a clinic in Belfast, in Dublin, 2 clinics in Dublin, but no one was able to kind of give us a clear pathway around how to do that. And as we went through that, you know, it became clearer to us that it was the right decision for us. So regardless of whether a clinic here or elsewhere was going to be able to help us, we still wanted to pursue it.
So what did you eventually decide to do?
Well, it was all getting very complicated. You know, one of the clinics was talking about having Brian, our donor, donate to one of the sperm banks in Denmark so that we could then buy that donation. Like, it was all getting extremely complex for everyone. And we kind of stepped back from it and said, well, there are easier ways to go about this. Yeah. So we started investigating, and, you know, I had no reason to think that there were any infertility issues with me. Brian already had 4 children, so we knew there weren't infertility issues there. So we started investigating intracervical insemination, which is a non-clinical process that people can do at home. A lot of people refer to it as at-home insemination. You don't have to be at home, but that's what people call it. So we started investigating that, and that's the method we used.
I would assume that was a lot cheaper than.
Yeah.
The kit on Amazon was like maybe €10 and then maybe 20 for shipping or something like that.
Well, I mean, it wasn't actually less costly for us in the grand scheme, because our donor lives in the US, so there was travel arrangements and all of that. So, I mean, as it happens for us, it wasn't that much less expensive, but certainly way more straightforward.
And way more personal and relaxed. And we had a really not a great experience in the clinic when we were going and trying with me. So it was just a much nicer, more personal, and really a better way for us. Very relaxed. It only took two tries. Yeah. 2 cycles. So it's a good choice for us.
When you became pregnant then, Elaine, were you guys kind of really focused on the pregnancy, or at that point was it kind of very apparent to you that once your child was born that there would, your family wouldn't be recognized?
Well, before we got pregnant, we did a bit of due diligence, and we spoke to a family lawyer around what our challenges might be. We met with them, and they kind of did up a report for us around what it would mean around guardianship and what the CFRA, which hadn't commenced at the time, was likely to do or not, and how everyone's rights would be impacted on it. And, it was grim, and we were looking for advice on whether to name our donor on the birth cert or not, and how that would impact on our kind of journey going forward. So the advice was grim, but even still, the decision was right for us. So we were fully aware of what we were getting into, but still felt like the choice, the option to choose our donor and the genetic makeup of our child should be ours and shouldn't be limited to, 2 sperm banks in Scandinavia.
Yeah. And then once Kate did arrive, were there any kind of immediate challenges that you faced? I'm thinking particularly because obviously, Jenny, you are an American citizen. Were there any challenges that you faced immediately when Kate was born?
The most immediate one when she was born was actually getting her birth registered. So Jenny and I are married. Neither of us took each other's surnames when we got married, so we kept our own ones. But we wanted, knowing that Jenny couldn't be listed on Kate's birth certificate, we wanted her to take both of our names to make it more straightforward for things like travel and childcare and whatnot. But also we wanted her to have both our surnames because she's part of both of us and part of both of our families. And that was extremely challenging in the birth registration office. Involved the superintendent getting involved, 3 or 4 trips to the birth registration office.
We had to violate our own donor agreement for them.
Yeah.
Which was ridiculous.
They immediately wanted the contact information of our donor to get his permission to give our child both our surnames, which we said we weren't going to give them. We had an agreement with him. He undertook to be a donor and an uncle to our child and not to take part in any of those decisions. And we were a married couple and felt that we should have the right to name our child as other couples have the right to do that. So that was extremely challenging and distressing and upsetting, to be honest, and involved in the end. The birth registration office would only register our child's birth with a double-barred surname if we produced a fully unredacted version of our donor agreement for them to keep on file, which still bothers me.
And it should. It just seems like such a violation for everybody involved. Yeah.
And citizenship, I guess you can speak to that.
Yeah, so the next challenge was when we wanted to take Kate home to meet her US family. Elaine had to sign the affidavit that said I didn't exist, which I think a lot of us have had to go through, which was really another punch to the soul. And then, so Kate, because I'm not on her birth certificate and was not from the start, won't have access to US citizenship through my citizenship. So she can't become a US citizen now.
Ever.
Yeah, ever. Unless both the legalities here and in the US change. Because as it stands, the US will only grant citizenship through parents that were on the birth cert in the place of birth at the time of birth. So even if you were able to get her birth cert changed, unless the US changed their laws, right. Which
it still wouldn't.
There are some cases going through now that hopefully will pave the way for us someday.
And I suppose how does this all make you both feel? I know, you're obviously, it feels different. I know as the parent who is recognized from birth, you're obviously in different situations where one is recognized, the other's not. Like, how does it make you feel that your child is being treated differently to other children?
Worried. Worry is the biggest thing for me anyway, because I mean, most people are sound, and you know, the law says one thing and people are compassionate and realistic when, you know, getting Kate vaccinated or taking her to childcare or any of those things that, you know, they don't question. But at the same time, for if someone did, or if someone did want to cause problems for us in hospital with travel or any of those things, they could, and the law would back them up. So it's more, you know, we're living in a very changing world where countries are, you know, pendulum swinging left to right all of the time, and laws and people are following the laws. So I think the biggest thing for me is worry, because if we were in a very vulnerable situation, which a lot of families are, where, you know, I passed away or Kate needed emergency treatment or any of those things, someone in that scenario could make a really bad situation an awful lot worse and be backed up by the law in doing so.
And what about you, Jenny?
It's just, for me, it's just a bit baffling, you know, because it's just so clear. Intended parentage is such a clear concept. And it's just baffling to me that in this country that is so progressive in so many ways is so lacking in this area and leaving these kids in such a vulnerable situation. So it's sad, of course. And I had to stop going to the registry office for all of those fights, and I couldn't look at the affidavit for the passport, and you know, it's very sad, and she's my kid, but for the most part, it's just baffling to me.
Yeah, I would agree with all of that. Okay, so to end on a more happy and positive note, because you are a family just like any other family, even though you are not recognized yet. What is your favorite part of being a family? What's your favorite thing about being a parent?
For me, it's just watching all these things in life that I forgot about happening all over again through her eyes. It's so incredible to see, oh yeah, you didn't know what a ladybug was. Look at this ladybug. Is this the most incredible thing you've ever seen? Like, it's just every day there's more of that. And as she gets older and her life expands a little bit, it's just, I can't wait to see where she goes and what she does. So for me, it's just kind of seeing everything all over again through her eyes.
What about you, Lynn?
Yeah, you know, we were talking about this recently. Children really force you to be present in your daily lives, and that presence is I think a richer life. It leads you to richer experiences. And the two things that come to mind with Kate and with all kids, you know, are that kind of unbridled joy that they make you feel, or that you see through them, and the unconditional love that they give the world and everyone in it. And it really kind of makes you feel, I think, more alive and present and joyful on a daily basis.
Gorgeous. Thank you for that. And thank you for sharing such personal aspect of your life. I know we all share more than maybe we would have wanted to share, but it's, I suppose, for the greater good, isn't it?
The American, she loves sharing.
Don't you have more questions?
I know. How could we be really invasive? All right, well, I'm now going to open it up to the floor. If anyone has any questions, we have a few coming in on the chat, which I will read out. Once I read out those ones on the chat, if anyone, you know, has any questions that you would like to specifically ask either to Lydia or to Elaine and Jenny or to myself or any of us here on the call, feel free to just unmute yourself and ask the question. If we don't have time to get to all of the questions, you can, of course, email either the OUTLaw Network or us at Equality for Children, and we will do our best to answer your questions. So we have a few on the chat here. Louise is asking, Can I ask when changes may be introduced and what they are expected to cover? Thanks again. So Louise, I would assume you're talking about legislative change. So who wants to take that first one?
So I can just say a little bit about it. I suppose the Assisted Human Reproduction Bill is on the priority list for the summer kind of legislative schedule. So it is anticipated that that bill would be used, it's firstly going to be mostly about surrogacy, but it would be used hopefully to amend certain aspects of the CFRA in the ways that I was talking about in my presentation to ensure that other types of families are included. So in terms of what changes we could expect to see, a lot of, I think what Professor Conor O'Mahony has suggested, well, we would hope that that will be included in the bill in terms of ensuring that our legislative scheme is in fact operating in the best interest of children. As I said, it's very difficult to ignore recommendations from the Special Rapporteur on Child Protection in that way. So his recommendations, I think, will be hopefully included in the AHR bill.
Thank you, Louise. I hope that answers your question. If it doesn't, feel free to ask another. Another one has come up on the chat here from Kieran. What does it mean to have a known donor? Is it literally someone you know, or does it include someone who is a registered donor? It's so bizarre that known donor assisted births cannot allow for retrospective parentage, but going forward, any donor has to be registered or else parentage cannot be recognized. Who wants to take that one?
I'm happy to take a stab at it, but Lydia may be able to correct me. There's a lot of terminology used for donors like anonymous, non-anonymous, traceable, known, and I suppose the concept is really there are three types of donor. There's anonymous or completely unknown, which is where the identity of the donor is not available to either the parents or the child at any point in the future. There's traceable, or what else is that called? Sometimes known as well, but traceable is non-anonymous, yes, where the donor information would be available to the parents of the child and to the child once they turn the age of 18, and that's on the on the National Donor Registry, or proposed to go on there. And then there's a known donor, which is a person who is known to the family. So it could be a person that you know, a member of extended family or whatnot, where the couple know the person and have asked them or are aware of who they are right from the get-go. And equally, that information can go on that national registry.
Lydia, do you have anything to add to that?
So just to say, the CFRA doesn't actually define the word unknown. It's a great piece of legislation. So it uses the word unknown, but it doesn't define what it is. So we just don't know until it's interpreted by the courts whether unknown means literally anonymous and you can't find out anything about them, or if it means identifiable but not yet identified. So we need the courts to clarify that point for us. But in terms of the legislation itself, it's open to interpretation.
Yeah. But there are three kind of types of donors. Yeah. Another question has come in from Max. Has anyone come across a case involving transgender people becoming parents? I'm a trans man and my girlfriend is a trans woman who has genetic material saved. If we had a donor egg and surrogate, would my girlfriend be recognized as a mother? I'd probably not be recognized if I don't carry the child or contribute an egg, I assume. Who would like to take that?
Not me.
That's a
I don't know enough about that.
Yeah.
So that would, I suppose, come down to the legislation on surrogacy. So at the moment, we don't have any legislation on surrogacy, and I understand this will be the topic for next week's discussion. So I'll happily push on the question to next week's expert. But just to say that, so at the moment, because we don't have any legislation on surrogacy, the way that things operate would be that the surrogate mother, as the person giving birth to the child, is the legal mother, and then whoever provides the sperm is the legal father. So those are it's very black and white in terms of who the legal parents are. The AHR bill, which I mentioned, which will potentially be passed or published during the summer, does propose a new regime for the regulation of surrogacy, which would, well, I suppose it depends on what way it's written, but which would have specific rules on surrogacy in terms of who the parents are. So we would need to wait and see. But for now, parentage is established in the way that I've just mentioned.
Thank you, Lydia. And yes, Barbara and Maeve have just popped up in the chat that actually next week our event will be specifically talking about surrogacy. So Max, absolutely, yes, do register for next week and there will be a lot more information on surrogacy. There is another question from Sandy. Hi, Sandy. Saying she's super late. Will the recordings be available? Yes, all of these recordings will be available. I think on the OUTLaw website, and we can pop them up on ours too. Kieran is asking, does the session next week include adoption as well? To my knowledge, we are not going to cover adoption, as these events are focusing on assisted human reproduction. Although I think, was it last week? Maybe someone can remind me. I think last week we talked a little bit about adoption, but it was more to do with adoption in the case of a child who's been conceived through AHR. So maybe it might be useful to look back on the other two recordings. Does anyone else have any other questions? Either you can pop them in the chat, I'll read them out, or feel free to unmute yourself and say hi and ask your questions.
I'll say hi again. Thanks so much for that, guys. It was really great, and great suggestion, Kieran. Maybe we can do a whole thing on adoption. You know, LGBT people adopting, whether they're adopting their own child born through surrogacy or yeah, adoption in general. So that's, yeah, a good topic. I had a kind of like a nerdy question about the law. I was looking at the definitions again of DAR procedure, and I don't think procedure really is defined. So like perhaps that could include intracervical insemination, but it does say that a DAR facility is somewhere where a DAR procedure is performed. So that's probably why it has to be in a hospital / fertility clinic. Is that right?
Do you want me to weigh in on that?
Yeah.
So again, I suppose if I plug the book again, I've gone into that argument in quite some detail in my book. But I suppose essentially my view is that the definition of DAHR facility is incredibly vague. So it could technically cover anything. Okay, so there's it doesn't actually say it has to be a fertility clinic or it has to be a hospital. It just says the place where the DAHR procedure happens. And then in terms of parentage being established, it says that the operator of the DAHR facility has certain duties in terms of collecting the consents and transmitting them to the relevant authorities. But the operator, I believe, is also very vaguely defined as someone who's just running the facility or who owns it. So I think there potentially is an argument to be made that your home could come within the definition of a DAHR facility, provided that you follow all of those, conditions and the procedures, collecting consents and so on. At the same time, I recognize that might be somewhat of an academic argument. So I don't rely on that as the basis for your conception. But again, I think it comes down to a huge issue with the CFRA, which is how vague it is. And there's lots of gaps in it and lots of things we just don't know how they will be interpreted until these things come before the courts. And that's really not an appropriate way for people to be establishing their families and trying to, do everything the right way without actually knowing what the right way is. So it is a major flaw within the legislation. But in terms of the definitions that you're mentioning, the DAHR facility, just looking at it, just means a place at which a DAHR procedure is performed. So it's rather loosely defined in terms of the legislation.
Thank you.
I just wanted to add one thing to the discussion about known donors. I think there are 4 clinics in Ireland with licenses they have applied for and received the licenses to work with known donors.
Non-partner
known donors. They all work with partnered known donors. But of the 4 of them, only one anecdotally might be working with actual non-partner known donors. So I think it is something that is coming to the fore in Ireland, and the clinics are starting to cop on to this idea that people would like to choose their own, genetic pathways for their kids. So I think it's starting to change. And in that case, there is a way forward for couples using known donors for being on the birth certificate right from the beginning. So there's a little bit of hope there, possibly.
But it also brings up an accessibility issue whereby technically since May 2020, families could conceive, or same-sex female couples could conceive with a known donor through a clinic that had a license to do so and be recognized as the intended parents of that child. However, if no clinic is offering that service, they can't.
Yeah.
Am I right in saying, just as you talk there, that Dr. O'Mahony's report allows for international surrogacy on the basis that domestic surrogacy isn't possible, kind of in the state, that there won't be enough surrogates coming forward? So perhaps we could make the same argument, although it would be good just to have it here as well, but if it's not available here, we have to be able to travel abroad for it, and so you should be able to use a fertility clinic not in Ireland, even though for cost reasons we should also be able to use fertility clinics wherever we want.
Or again, for cost reasons, to be able to cut the clinic out. I mean, some people can't afford treatment in clinics, so it's discriminatory in that way as well.
Yep. Yeah, I find it completely bizarre that you'd be able to use the exact same sperm in a clinic and pay for it, but you can't do it yourself. That's just completely bizarre to me, that the only difference there is paying thousands and thousands of euro.
I think ultimately it comes down to regulating conception, which is all fine in theory for donor-assisted reproduction, whereby there are fertility issues. But the majority of children are born through unregulated conception. So I think, that those kind of presumptions of maternity and paternity and that trust that's handed over to the majority of people should be available to others as well.
Absolutely.
Yeah. I think that's another striking discriminatory point when, Lydia, you spoke about the presumption of parentage for a married couple, that the father would be presumed, and maybe in the majority of cases that father is actually the biological father, and so that's probably why they brought it in. But if you look at all the other things, were they together at the time when they planned to have the child? Did they go through the pregnancy together? If you look at those things that a married couple or a couple that is together, would also have, it seems like that should be, that a same-sex couple, married couple, should be able to avail of that. And that's not a solution. I'm just looking for ways to chink in here. But do you think there's an argument there, Lydia, that could be made on discrimination grounds?
Well, I suppose on its face, opposite sex marriage is different to same-sex marriage when it comes to children, because there's no presumption of paternity in it. And I think you could certainly say that is discrimination. At the same time, if we think about our discrimination laws, they kind of allow for discrimination to happen in a way. So Article 40.1 of the Constitution, which says that we are all equal before the law, but the state is entitled to take into account our differences of capacity, physical and moral. So in the MR case, which had to do with surrogacy, which went to the Supreme Court, one of the arguments was that we shouldn't have different tests for paternity and maternity. However, as far as I can remember, that argument was rejected on the basis that, well, men and women are different. So we can determine maternity on the basis of giving birth to a child, and paternity is on the basis of your genetic relationship to the child. So I think that argument potentially could come in to say, well, maybe the two types of marriage don't have to be exactly the same, but just because they don't have to be exactly the same doesn't mean that, you know, they can't be. It's still, we could make them equivalent by having a presumption of parentage in both cases. Probably an unpopular view, but my personal preference would actually be to have no presumptions. I think the presumption of paternity is actually quite damaging in and of itself, because in many cases, the husband is not the legal father, so you're kind of perpetuating a myth. And it would actually be better to have our laws truly based on the best interests of children, to have a more nuanced approach. So my view would be, rather than extending a presumption of parentage to same-sex couples, that we actually just make our parenting laws appropriate, and to have, appropriate rules that would cover different situations, rather than these kind of blanket statements that might not work in every situation. Of course, the presumption of paternity is rebuttable, so I'm not saying that it's, a totally inappropriate thing, but it does come from a different time in family law. So perhaps it is time to think about a different way of conceptualizing that type of presumption.
Does anyone have any other questions before we start wrapping up? You can either pop them in the chat, or, as I said, unmute yourself. Now is your chance.
Yeah, I was just going to post in the chat and be like, I'm going to ask another one unless somebody else does. So I'm hogging, but yeah, it's just great to have the personal and professional experience here, and just, I feel like things come, it's such a complex area that things just come to you as you think about it and talk about it. And one of them is, I think, Lydia, you said that it's kind of linked to the presumption that it's possible for a father to apply for a declaration that, no, the presumption doesn't apply, or this is my child, and do a paternity test. Is that possible? Because I think a very weird quirk of the law, is that in a case of reciprocal IVF, the person that gives birth is the mother, even though they may not be the biological mother. So would it be an option there for the biological mother to make a declaration or to seek a declaration, or is it only for fathers?
So as far as I know, it's only for fathers, and that comes down to the fact that we determine paternity and maternity differently. So because paternity ultimately comes down to genetics, the husband can rebut his presumption of paternity on that basis. But because maternity is not about genetics at all, it's about the fact of giving birth to the child, there's not a way to rebut it, in the same way that you could for men. So no, at the moment, there is no way of rebutting maternity.
So I can't give my kids back then. We did reciprocal IVF, for anyone who doesn't know. So I'm not the biological parent, but can't send them back.
But again, I suppose from a legal perspective, that who is the legal mother was the question in the MR and Untitled case, so the surrogacy case that went to the Supreme Court, and a lot of those similar arguments were made, and ultimately the Supreme Court said, under our law as it stands, maternity is determined on the basis of giving birth to the child. So that's the definitive statement of who a legal mother is, in the absence of other legislation coming in.
It's interesting to me that one of them is defined by like the physicality of it, and the other is determined by the genetics. Surely it should be the same.
Well, it's also a point that, you could have Ranae on your way into the registry office, as could have Elaine grabbed a punter off the street and put him on the birth cert. But your wife and Elaine's wife can't go on the birth cert. So it's just, the laws. It's
crazy.
They need some fixing.
Okay, if anyone doesn't have any other burning questions they want to ask, we might just wrap it up, because we're just coming up to 2 here. Lisa is just saying, thanks so much, learned so much from the personal and the legal, and yeah, I agree, it's nice to have both sides of it. It's important to get the full picture. So I just want to say on behalf of Equality for Children, and I didn't even mention this when I was just so excited to talk to Elaine and Jenny. Elaine is actually the chair of Equality for Children, and we absolutely would not exist without the work that she does. So thank you so much. But thank you to the OUTLaw Network for partnering with us for these events, and thank you so much, Lydia, also for your time and your expertise. I always say about you, she literally wrote the book, you know, on all of this, quite literally. So thank you so much, and I'm going to hand back over to Maeve now to finish.
Yeah, thanks. Just to say a few thank yous from me as well. It is so striking that, you know, when people share their personal stories, and it is, you know, it's kind of the most personal thing you can really do. So thank you again for doing that, and it means a lot, and I think it does really help to show how this law is affecting families and children. And Lydia, thank you, able to answer all those really tricky questions, and it's brilliant to have you here. Thank you to the Outlaw Committee for supporting the idea of this event, for Sean, who just said, why have one event when you can have 4? So I'm really glad we've done this series. And thank you to Harrison Maloney, who is co-chair of our student committee, for the fabulous posters which you'll have seen on Eventbrite and social media for this series. So that's all. You have the registration link for next week. We hope we'll see you there to continue the discussion. Follow Equality for Children and Outlaw on social media, sign the petitions, do the non-trad fam survey if that applies to you, or send it on if it applies to anyone you know, and let's fix this, as someone said. So thanks everyone, have a good week, we'll see you next Wednesday. Bye.
Thank you.